Hi, everybody. Thanks for tuning in. We appreciate it. We're glad you're here with us. Tim Andersen here, the appraiser's advocate, and we've got one of the movers and shakers of the real estate appraisal industry here with us today. We've got Craig Capilla. Craig, how are you?
Excellent. Good morning, Tim. How are you today?
Great, thank you. I appreciate you asking. Now, Craig is not an appraiser, true. He's an attorney, but yet most of his work is working with appraisers. And we're grateful for the input he gives us because, I mean, that comes right from the front of the battlefield. Now, while Craig is an attorney and he does defend appraisers against charges, either from the state or even federal, Craig is not here to give us legal advice today. If you need to get in touch with Craig for that legal advice, we'll give you that information in a couple of minutes. But Craig is here today to answer questions, to give us a perspective on what's happening in certain aspects of real estate appraisal, but he is not dispensing legal advice. Now that we've got that out of the way, Craig, if somebody does need to get in touch with you, how do they go about doing that?
Thank you very much, Tim. So I can be located, I'm based out of Illinois. I'm in the north suburbs of Chicago. And if somebody were to go to our website, which is fgcclaw.com, you can find all of the contact information there. You can find the email address, you can find the phone number, and that's our firm we have here. It's Franklin, Greenswag, Shannon, and Capilla. It's a 9-lawyer firm, and we work on a variety of items. But yeah, you're exactly right. My area of focus tends to be in license law and professional liability, and specifically focusing a lot in real estate related matters, and again, even more specifically with appraisers. And if you go to fgcclaw.com, you can find out all about that stuff on there.
Okay, Craig, thank you. Now, you started out as a prosecutor with the Illinois Real Estate Board. You prosecuted both appraisers and real estate brokers, right?
Correct. That's actually how I got into the appraisal space. Was I actually came in as a regulatory prosecutor. Prior to that, I actually thought I was going to be a transactional attorney. Really had no intent to litigate, and we were doing real estate transactions. Illinois is an attorney state. Not every state is like that, but Illinois is an attorney state. So every real estate closing you can think of, you've got attorneys representing buyers and sellers and the like. And that's the area that I was in. Um, Roundabout late 2007, the faucet basically turned off for us as far as sales volume. We knew we were in trouble probably September, October of '07. And sure enough, we know what happened in walking into 2008 as the economy took a dive. So I actually had to start looking around for a new job at that point. Going into government seemed like it was going to be pretty stable because at least the paycheck was going to show up when it was supposed to. And I started with the regulatory agency for the state of Illinois that covers all of the professional licensing, everything real estate brokers, appraisers, home inspectors. We license them here in this state too, and everything else, doctors and accountants, and you name it. One main agency there that handles all of that. And I started with them the Thursday of the week that Bear Stearns collapsed. So I timed it pretty well.
Yeah, you did. So you were on the dark side, but you came over to the bright side, and now you defend attorneys against state boards. And just this is a personal note from me. I've worked with Craig with a number of appraisers in a number of states, so Craig is able to help. And just tooting Craig's horn for a little while, I've never had anybody call me up and say, Tim, why'd you suggest Craig's name? They've called me up and said, Tim, I'm surely glad you suggested Craig's name. So a little toot of your own horn there, Craig. So let's get into what we wanted to talk about. Now, I told you that I was reading an obscure magazine recently, and there was an article in there by an obscure attorney in Chicago. Oh, you. And you were talking about, it's called Why an Organized Work File is Your Best Defense. Now, this is not the only thing we're going to talk about, but let's start talking about that. So, the appraiser calls you up, says, Craig, I'm in trouble. And you say, okay, well, send me your appraisal, send me the work file. Let me start going through it. And you get the work file, And here is a work file for, say, I don't know, $750,000 property. And the work file is about 4 pages thick. And 3 pages of those are MLS printouts. Should that appraiser just basically send their license back at that point? Or is there a defense anywhere there?
I mean, there is a defense, but I think we're going to have to go out and go looking for it. And that's part of the problem that we see here. I appreciated the opportunity to take on an article about the work file. That was at the suggestion of the fine folks over at Appraisal Buzz, and they were like, "Well, do you think there's anything that you can comment on the work file regarding this type of claim and that type of claim?" I was like, "Oh boy, do I have some comments on that." Tim, you know, I've seen each other at countless professional events now, conferences here and there and the like. I can't think of a single time I have gone to a conference, presented in front of a room of appraisers, and haven't caught a question about the work file. It seems to be the most mysterious area of anything that I end up dealing with on a regular basis. And for me, it's the most important part that I deal with. As I'm fond of telling people, you know, it's great that, you know, you think I know something, but really I'm only as good as your work file. Okay. At a certain point, my ability to defend claims against you, to put you in the most positive light, to explain away what some others might think is a deficiency, all of that's really contained within the work file. Are we able to support what you did, why you did it, and can you actually back up the claims you're making? And for me, that's really what I look at when I start looking at a work file. It's okay, let's start from the ground up. First off, what do we have in here? Do you have everything you need in here? Can you get access to the sorts of things that you were considering or relying on, and you didn't preserve it in the work file in real time, but is it still accessible? And can you show that that's what you were relying on when coming to your conclusions, when rendering an opinion, when doing your analyses? And then ultimately, I like to remind people, sometimes keeping things in the work file that you considered but didn't rely on is every bit or more important than keeping the stuff that you did rely on. Because I've had it happen, I don't know how many times now, where whether it's in a board hearing or a board conference, or even in a lawsuit, in a liability claim, the other side introduces him, well, why didn't you consider this piece of data? Well, if you can't show us that you did consider it at the time, you're going to be left stumbling for an answer. But if you have it right there, it goes, no, it's right here on my farm list. I absolutely considered it, and it wasn't appropriate to use for these reasons. I had it, I thought about it, and I used my judgment to determine that it wasn't a good fit for this subject. If you can do that, you can get yourself out of a heck of a lot of sticky situations.
Let's take the microphone off mute. Okay, now let's talk about that situation. What you didn't use. Now, in the record keeping rule, USPAP makes it clear that you need to have a record of what you use to come up with your value opinion, as well as what you didn't use to come up with your value opinion, assuming, of course, that's appropriate. Now, you find just a lovely property, and it's next door to the subject, and it sold 3 weeks ago, and it sold for $450,000, and the neighborhood is typically, $375,000 to $550,000. So it's right there, and you use it, and the adjustments come out to less than 10% gross adjustments, and you think you've got this one absolutely nailed. Well, pretty soon you get a letter from the state and somebody's complained. So you're sitting there in front of the, even before the state board, you and your client are speaking. And of course that's confidential, obviously, but you say to the appraiser, okay, now, how did you verify the sale? And the appraiser says, well, as you can see in the work file, I got it out of MLS. And you say, well, okay, did you ask any Other questions? Did you call anybody up? Did you call a broker? Did you call a buyer? Did you call a seller? Did you call a closing company? No, 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 and no, no, no. Okay, so you're sitting there in the state board, and the guy who you used to, or who now sits in your chair where you used to sit, says, "Okay, Mr. Appraiser, we checked this out, and yeah, it sold for $450,000." But to get the buyer to pay $450,000, the seller had to throw in a boat, motor, and trailer. And you didn't mention that. And you didn't reduce the sale to cash equivalency. So you want to tell us why you didn't do that? And now the deed said $450,000. We're assuming a full disclosure state. The deed said $450,000. MLS said $450,000. So the appraiser said, yeah, it's a $450,000 sale. But obviously it wasn't, for the reasons I just stated. What kind, if any, trouble is that appraiser now in with his or her particular state?
It can be significant. And one of the concerns that we have is data verification. And of course, that goes to a work file concern of how are you preserving your efforts for data verification. You know, when you started posing that scenario, admittedly, I chuckled a little bit because I'm fond of seeing on the typical GSE form report, you know, data source, MLS number, XYZ, ABC 1, 2, 3, 4, 5, 6, 7, verification source, public record. It's always public record, isn't it? Every time. Where'd you get that from? Well, I went to public record. Well, what was that? Where did you get that from? I mean, I will tell you that many of the files I see, we don't even have adequate preservation of, say again, full disclosure state. You went out, you pulled a copy of the deed, you threw that in your file. You even just went to the recorder and printed off the form that shows that something was recorded on that date for that. Most of the time, I don't see that information in there. However, again, if we're being particular about this, I do think that is required here. I do think that is a necessary component of compiling a work file. What is, you know, what does it tell us? And I promise you folks, this wasn't a prop. This actually does just sit on my desk all the time, but it really is. I mean, you know, it's not just a fun read in the evenings. It's worthwhile to have open and refer to every once in a while. What does USPAP tell us about this? Which is pretty much the adoption of every state verbatim as far as work file goes. Data, information, and documentation necessary to support the appraiser's opinions and conclusions. And here's a little hook on this one we'll come back to in a second, and to show compliance with USPAP. Now, I think, Tim, you're probably up on this. Many of the viewers may not be yet, but we also know that a change is coming. There's a variety of areas that are changing in USPAP, but in particular, the Appraisal Standards Board has changed the definition of work file. The new definition of work file in USPAP will read documentation necessary to support the appraiser's analyses, opinions, and conclusions. Full stop. So they've removed a few words, data and information. They figured that was redundant. So they're just saying documentation now, singularly. That's supposed to be all encompassing whatever the material is. They've added to support analyses. They didn't have the word analyses in there before. It used to be to support appraisers' opinions and conclusions. It's also now to support your analyses. Okay, so think about the implication of that. And they've removed that last clause, and to show compliance with USPAP. This is no longer going to be a feature of the definition of a work file. So people are going to have to sit around and think for a little bit what the implication of that is. Why are we taking that additional step, that additional clause out of here? And I think depending upon the area of practice you're in, are you in consulting and litigation support? Are you in lending work? I think that's going to have different implications for you, but it's really something to consider here. The definition of work file is changing. Is it changing for the better? Is it changing for the worse? I mean, only time will tell, but it's changing, and everybody's going to need to get on board with that. I will say one thing that is a clarification that's important is that you need to have the documentation to support your analyses, opinions, and conclusions. So that has broadened that up a bit. So I think most people are comfortable with the idea that, oh, I'm supposed to have documents that support my opinion and the conclusion that I drew here. Nope, you're supposed to be showing how your analyses are supported as well. Why? Because that support is going to help a reader, a reviewer, a regulator determine whether or not your work is credible. Is it supported by something? So I think that is actually a significant change here. I think that's actually going to help guide people towards building a better work file. But again, Tim, in the scenario that you referenced there, I think it's significant. Where are you showing, even in your handwritten notes, oh, on such and such a day, I called this agent to verify the sale of whatever. That might be all you need. That could be more than sufficient. But now we can show affirmatively that we've taken that step. We have verified the data. And now that helps support our analyses here, whether to include the sale or not include the sale. At least we have that information. Because conversely, it could be, oh, you know what? Look at this one down here. I saw this. I gave 3 beds, 2 baths, a split level, and there's a sale right down the road at 450 and you didn't include it. Explain to me why you didn't do that. Well, see, on the 17th, I called the selling agent for that one and they told me they had to throw a boat and a trailer in. So as it turns out, it wasn't a very good fit for our subject. So I declined to use that sale as a part of my analyses. There's the part where you're preserving information about data that you decided not to rely on, and it could really save your bacon at some point.
All right, the concept of saving your bacon. And let's go back to the issue of now we're talking about analyses, not merely documentation. Now, analyses is, of course, plural for analysis, which, by the way, USPAP does not define. It just assumes that the appraiser knows how to analyze. So you're doing the cost approach. And now a lot of appraisers don't like the cost approach. Okay, I do, and which is why I'm using it. So you're doing the cost approach and you do it one time and you throw that in the report and you say, there isn't very much there. I don't like the cost approach, therefore I did it, but I didn't give it any weight. Is doing the cost approach one time analysis, such as USPAP contemplates, or is doing it numerous times to see what those various iterations tell you about market value, the proper analyses that USPAP expects to see in the work file?
I'm going to suggest that if you just take one crack at it, throw it in the file as a throwaway, you have not plumbed the depths of this sufficiently for what they're looking for. I look at this as this is a standard 1 development problem for me. How do you know whether or not the cost approach is applicable to this assignment if you haven't fully developed the cost approach and you don't have enough information to reliably, credibly make a determination as to whether or not it's relevant? We've got 3 approaches to value. Our response here in every assignment is to consider the 3 approaches to value and then give the most weight in the reconciliation to the one that will convey the most probable, the best, nearest opinion of value, right? I think it's easier to talk ourselves out of an income approach because I think the income approach tends for most people to function more like an on-off switch. I have a whole bunch of available rental information. I have a revenue grossing facility. I have income. I can figure this out. Single family residences, no real rental market in the area. These are predominantly primary homestead residences. Okay, great. We can probably turn the income approach off. I can't guarantee you that. You still got to give it some thought, but you may be able to arrive at not applicable to this assignment more quickly. With the cost approach, I love the cost approach conundrum because I think a cost approach done well often does a great job of supporting opinions rendered in the sales comparison approach. I rarely come across a cost approach done well. Now, admittedly, a lot of what hits my desk is getting here because there's already smoke and somebody is now suggesting that there's fire out there. So whether it's turned in as a board complaint, whether it becomes the subject of a lawsuit, somebody's expectations have already been missed. We're probably going to have to talk about some of the mechanics of that. But when it comes to the cost approach, the most common response I get, and based on the consulting that you do and working with appraisers and trying to improve their work product, I suspect you hear a lot of the same thing. Oh, okay, here's an assignment from a year ago. We're going to use this to build up and work on. And in your instance, in my instance, somebody's complaining about this work I did a year ago. All right, I'm going to spend a bit of time on the top half of page 1 of the URAR. And let's see how well we did in our inverted pyramid, filtering down the information to go from macro to micro. Now let me flip over and let's take a look at the cost approach. Whew, I see a few round numbers in here. I don't see a whole lot of words here. All right, why did we do a cost approach? Well, the client required it. Okay, that's the most common response. Well, I don't know if it was really good here, but the client made me do it. Well, that's not a good answer. I'm still, I'm over a decade out of being a prosecutor, but the way my mind works is still, if you do it, you have to do it right. There's no substitute for that. And so when it comes to the cost approach question, I do think actually taking the time to understand how to properly develop a cost approach goes a long way. And I'm just going to drop a little Easter egg here and say that, Tim, I think there's a part of the conversation we're going to turn to a little bit later, and we're going to come back to this idea of people understanding how to do the cost approach the right way.
Yes, I think we are. All right, let's transition to another area, talking about the fact that there are complaints, there are lawsuits, etc., that are coming up against appraisers. Let's talk about Connoly and Mott v. Lanham. Now, just as a background, Dr. Connoly and Dr. Mott are professors at Johns Hopkins University, and they, obviously, you don't get to be a professor at Johns Hopkins University on a fly-by-night basis. So these are people who have solid academic reputations, highly educated. And the appraiser came in and appraised their house, and the appraiser, Lanham, and again, I'm not blaming anybody. I'm just using the names because the suit's public record. The appraiser, Mr. Lanham, comes in and appraises it for, I don't remember the number, but Doctors Mott and Connoly didn't like it. So they filed a lawsuit, and then another appraiser came along and appraised the property significantly higher. And that is one of the bases for the lawsuit, that because Doctors Connoly and Mott are black, that Mr. Lanham engaged in bias. This is what the suit alleges. Now, the original suit, Tate Austin v. Miller, settled. So the questions that case raised were never answered. At least they were not answered publicly. We can't, the judge did not opine, therefore there's nothing we can learn from the judge's opinion. However, Tate Austin v. Miller, Connoly and Mott v. Lanham is still pending. Now, it may settle too, we don't know, but it's still pending. And in many instances, the questions that Mott and Connoly v. Lanham are asking were the same questions in Tate Austin v. Miller. So given the fact that, now you're not involved in the Lanham case, But given what you know about it, um, what are the issues? Where does it stand? Do you think this is going to settle, or do you think this is actually going to go to trial, and therefore a judge is going to a judge is going to answer some of the outstanding questions of the case, among which is the question, is the sales comparison approach inherently biased?
Well, and that's it in a nutshell. And I think that that's the key component, at least in my mind, that we're all waiting on an answer, frankly. I'm going to take a little bit of a side run at your question, and the reason being, Connoly and Mott v. Lanham is still out there and still looming. In the interim, we've had a handful of other cases pop up, though. There is, this is right now, whoever is a commercial appraiser, who's ever certified general, who does not focus on residential, their eyes are glazing over as we're talking about yet another residential bias case. That's all well and fine until you start paying attention to Cincinnati and come to realize that in Cincinnati, there's a lawsuit pending against an appraiser and against a lender on a commercial property. Now, it's a rental property. It's a multi-unit residential rental property, but nevertheless, we're talking about a commercial loan. So certified general appraisers, don't change the channel, okay? This is coming. It's out there. You need to be aware of these concerns. We also have additional lawsuits in North Carolina and in Connecticut. And again, some of them are earlier in the process than what was going on in California, and then the Lanham matter, which is in Baltimore, Maryland. But we're seeing all over the country now these types of items popping up with some more frequency. And I don't see any reason why that's going to change anytime soon. But really, a central question to all of these is, yes, it is the specific actions of an appraiser or an appraisal management company in their approval, acceptance of an appraisal, or even the lender in their acceptance and reliance on an appraisal. That's what's being questioned. That's who's being accused in these matters for various steps. But Tim, you're right. Going back to something that I know we've discussed previously, it's really a matter of the sales comparison approach being tested. Really, it's the sales comparison approach being put on trial. If we go back to some of the language in the Tate Austin v. Miller case, which was the Northern California matter, one of the items that we ran into first was they really laid out the history of property valuation throughout the United States. One of the things they focused on was the formative era for even many of the appraisers that are out there today, from the earliest texts all the way into 70s and the 80s and coming into the advent of licensure. I mean, they specifically pull a quote out of the 1924 edition of the Frederick Babcock book. And it comes out and states explicitly, the habits, the character, the race of the people are the ultimate factors of real estate value. Okay, that's a pretty damning statement in print. And that's a book that for more than 50 years was relied upon as a foundational text in property value. So that's a significant one. We know that for a while, the author of that book was a head of underwriting at the FHA. Okay, so now we've got some legacy concerns here. Then further in that complaint, when they start describing their alleged wrongful acts of the appraiser, again, this is the California case to start with, the complaining parties here, the plaintiffs, allege that the appraiser should have selected comparable sales outside of unincorporated Marin County and Marin City, where it's at, that were more closely analogous to the subject, meaning, bedroom count, bathroom count, but they should have taken things outside of the immediate area because the racial, and they failed to do so because the racial demographics of the surrounding areas were different than Marin City's. For example, they reference Sausalito and Mill Valley that should have been used as comparables. Well, at least at the time that I was looking into that assignment, it looked like the surrounding area where the subject property is located had a median value somewhere in the upper 700s, if I recall correctly. Don't quote me on that exactly, because I don't have that data in front of me right now, but I seem to recall it was median home values upper 700s to around 800. Right next door, Mill Valley, one of the neighborhoods, one of the communities referenced by the plaintiffs, saying the appraiser should have gone to Mill Valley. Median home value, I think, was 1.7 in Mill Valley. I don't mean to denigrate their position any, but look, folks, I live in the city of Chicago. We're not known for low property values in the city of Chicago. In fact, values are pretty high. I too would like my house compared to a house in Mill Valley. Okay. Nobody's going to do that for me, but I guarantee you the value of my home would go up significantly if compared to another 4-bedroom joint in Mill Valley. Okay. This is what's being questioned here in these cases: the selection of comparables, what's being utilized by the appraiser as a filter of data. Same thing all over again now to the case that you brought up, Tim, in the Lanham matter. This, again, rests solely on the use of the sales comparison approach. Now it's a matter of which side of a major thoroughfare the appraiser was selecting houses from. This is in the Baltimore area. This is a matter where there's an area called Homeland, but limited a search to north of what's called Northern Parkway. So by their math, that excluded over 80 potential sales out of roughly 100 available sales that could be used to determine what's comparable to the subject. Okay, so if that happens, we see an extreme shrinking of the available data to be considered if you're going to use that barrier. So again, it's a matter of how are the appraisers filtering their data, specifically in the sales comparison approach, and primarily turning on geographic considerations. That's dictating what available data is being analyzed and compared to the subject. And ultimately, when the value is coming in short of the expectation of the borrower here, the borrower in these cases is pushing back and saying, you improperly excluded available information, you failed to analyze, you intentionally chose to omit available data, and the reason that you did so was because of race, creed, color, the protected classification they're looking at. And that's what's triggering a fair housing claim. So again, we don't have clarity right now on whether or not a court, a judge, a jury is going to come around to actually answering some of these questions. But at least as it stands right now, we have multiple occurrences of legal complaints filed, really testing some of the foundations of the sales comparison approach, specifically going to location, location, location. And that's what's being tested here.
Craig, let me back up. You used the word filters. What filters did the appraiser apply to the data? Why did the appraiser apply those filters to the data? Now, I want to tie that back in to what we were talking about earlier relative to work files. So what you're saying is part of an appraiser's analyses, again, the plural, part of an appraiser's analyses would be to document the filters as well as to explain why the appraiser chose to apply those filters. Is that correct?
Oh, that's absolutely correct. And that's another one of those areas I look at it. That question comes up for me frequently in, is this a part of the appraisal process? Is this a task to be performed by an appraiser, or can the assistant in the office or some other data collector, whoever, can they do this sort of thing, whatever particular task we're talking about? But oftentimes it comes to determining the market area and ultimately obtaining sales for consideration. Well, who can we have pull all the sales? It says, well, that depends. We have to refine that question a little bit more. Who's deciding which sales to compile? Yeah, I got a 3-bedroom, 2-bath house over in this area. So why don't you go out and find me every sale you think is a good fit? No, you don't get to delegate that. That's appraisal process. That's analysis. You're determining what the filter is. Because you know what? If you've got a 3-bedroom, 2-bath house, you probably don't need the 7-bedroom thing a quarter mile away. And you know that. So you get to set that filter. No, I'm really focusing on, I want some 2 bedrooms, I want some 4 bedrooms, but I primarily want to focus on 3 bedrooms. I want some 2.5 baths, I want some 1.5 baths, I want a 1 bath, but I primarily want 3-bed, 2 bath because that's going to be the most similar to the subject that I'm dealing with. That's analysis. That requires engaging your appraiser brain. That's your specialized knowledge and training that you've built up over time. Preserve that. When the question comes in later, what did you consider? You have to have an answer for that. Where did you set this filter for the data? Did you set it on a particular school district? Preserve that, write it down, explain so the reader can understand why. Heck, I know this is crazy idea here. Maybe even make a comment on that in your report when you're developing. This is what I did as I was performing the sales comparison approach. I focused on 3-bedroom, 2-bath properties that were located in this school district because that's where the subject is. Give us that information, but also, yeah, preserve that as you go along. Even if you're not going to go in depth with every single thing that you considered that you made a determining factor, it had better be somewhere in the work file because we need to have access to that. UsePAP requires that of us.
Then would it be reasonable to conclude that the overabundant use of boilerplate, while it may save an appraiser some time, may come back and bite them on the butt?
It certainly can. Like I am not an enemy of boilerplate. I want to be very clear about that because this is another one of those areas where the viewers are going to start rolling their eyes. Ah, of course, in a vacuum, these two guys could talk all day, but if it was ever actually up to them to write a report, it would take them 3 weeks to write each report because it would be War and Peace. No, it's not what I'm saying at all. Boilerplate is fine when it works. The problem that I run across most frequently is boilerplate that either uses a whole lot of words to tell the reader nothing at all. It's not doing anyone any favors and can actually start to undermine the credibility of the reporting. Or worse yet, boilerplate that doesn't apply to this particular assignment and is outright wrong. I get that from time to time. It's not a good scene when that pops up. Boilerplate works when it's appropriate to the assignment you are performing at that time. I am no enemy of boilerplate at all, but it has to fit. It has to make sense. If you go and use a whole paragraph to tell the reader nothing at all, then just remove that paragraph. You've done nothing to further the credibility of the work. If you use an entire paragraph to talk to me about the characteristics of Jonesville and your subject is in Smithburg, we're gonna have a problem.
One more question on Mott Connoly v. Lanham, and then we're going to move into the last question because we're running out of time. Mr. Lanham has countersued doctors Mott and Connoly for slander and defamation. Is that not true?
Correct. That is correct. In essence, the thought process behind that claim is that the plaintiffs not only filed a lawsuit, but then also went on to talk to various news outlets. Articles have been published, news segments have been produced for airtime, and that the claim of defamation hinges on the idea that, well, the plaintiffs are wrong. They knew that they were wrong. They know that these allegations they're making are incorrect, and they've gone out and publicized these allegations. So with that set of facts, again, this is allegations floating back the other way with They know they're wrong to bring this case. They know they're wrong to make these statements about me. Ergo, they're defaming me. They're harming my reputation personally and professionally, giving rise to a defamation claim.
Okay, and we will come back to that, not in this podcast, but as this progresses, we'll come back to that. Now, one last question, and you hinted about it earlier, and this is when we were talking about work files. If you were working with an appraiser and you got all done, and the appraiser realizes there's some problems, and chances are there's going to be some kind of sanction levied against the appraiser, and the appraiser said, "Okay, Craig, what is it I can do? What class or classes could I take to become a better appraiser so that I understand better what I'm doing and don't make this mistake again?" What would you recommend?
So I have a couple different ideas. Folks, you'll probably notice I keep doing that dirty attorney trick where Tim asks me a question and then I answer whatever I would like the question to have been. Okay, so if you ever find yourself in the hot seat answering questions, one friend to only answer the question you're asked, but I can get away with it here because I'm not under oath and Tim is entirely too nice to me. So what I'm going to say here on this one is there's a couple of different approaches, I think, as far as furthering one's education. And I almost said continuing one's education. It becomes dangerously close to continuing education. And again, everyone's changing the channel again if we're talking about that. It's not that. I think if we're talking in the context of actual appraisal practice, appraisal specific educational opportunities, it's not just one class, quite frankly. I am a strong proponent in people needing refreshment on the basics from time to time. I grew up in an environment, in an era where coaching was, it's the Vince Lombardi. Every time the Green Bay Packers would lose a football game, the next practice starts with Vince Lombardi standing at the 50 going, "Gentlemen, this is a football, okay? We're going to go back to basics." I think the educational structure for appraisers is imperfect, I'll say. The reason I say that is in the first 75 hours of education, you get 15 hours of USPAP, and then you get principles and procedures. And then in many states, you're given a license to go out and be a trainee or a licensed appraiser or whatever you want to call it. And then you've got this next segment of courses, and you start to decide, I'm going to work towards certification, Cert Gen, Cert Res, whatever it is. And now I've got an additional X hundreds hours of education on report writing and the sales comparison approach, highest and best use analysis, the cost approach, the income approach, case studies and report writing. And so everybody takes those and then goes out and practices for 10 or 15 years and never goes back and revisits those. I think that's a tremendous disservice, quite frankly. The first 75 hours of classes, the 15-hour USPAP, I think people should go back 2, 3, 5 years into practicing, take the 15-hour USPAP again. Well, why I take the 7-hour every cycle? Why should I have to go back and take that again? Well, simply because you're now out in the field. You've got experience. You've got your sea legs at this point. If you go back and take that 15-hour USPAP course, I guarantee you're going to get something different out of it, because now you'll sit through that class and you'll go, "Oh, holy smokes. That's how that's supposed to work." Because a year and a half ago, I had that come up in assignment. That's what that means. When you're throwing that at someone as their first course, and look, I'm not going to tell you I have a better idea for how this works because it is foundational, right? Those are the standards that you have to abide by. So you have to set them out at the front before you turn anyone loose. But I'll tell you, 3 years, 5 years, 10 years into your practice, going back and sitting through that foundational course again, you're going to absorb that material a whole lot differently. That's really true of any of the qualifying education courses. I don't care if it's principles, if it's procedures, if it's report writing. I said the Easter egg earlier that we're going to come back and talk about this again. Folks, if you're in the habit of working on a cost approach and you haven't taken a cost approach course in 12 years, go take it. It's going to mean something different to you now because you're actively practicing in that space, okay? It's different when you have now begun to use the techniques. It feels different, it reads different. I cannot begin to tell you what a difference it is to sit down and read an outline, a treatise, a course book in contract law. Because all of these years later, I'm swimming in contracts all of the time. When I was 23 years old and didn't want to know any of these things, I have to get through contracts and I'll do that and that's fine. And then when I'm done, I don't have to think about any of this stuff anymore. Well, how wrong I was. I'm knee deep in contracts every day. It really takes on a different feel. It takes on a different depth of understanding when you've now got your own built up experience to apply back to the premises that are being advanced in the classes. So I think from an appraiser education perspective, I would really urge people to go back and take some of those foundational classes over again. You'd be surprised how much you get out of revisiting the basics, because it means a lot more and it means something different when you're X number of years into your practice and you've got that wealth of experience now that you can tie back to it. That's the type of learning that is significant, really. Outside of appraisal education, I would suggest to people who are so inclined, consider finding your local college. It doesn't have to be Columbia or Princeton. Find a persuasive writing course. One of the biggest drawbacks, perhaps the biggest drawback I find in my practice, is that the appraiser typically knows what he or she is doing, why they're doing it, and they have a very good understanding of how they've arrived at their conclusions and ultimately at their opinion of value. They tend to do a poor job of conveying that to their reader, whoever the client is, whoever the intended users might be. And frankly, for the regulator whose desk it lands on, or the reviewer sitting halfway across the country in a cubicle, or whomever, it becomes a problem. Consider taking a writing course to tighten that up so you actually know how to convey information. But more importantly, consider taking a persuasive writing course. Creative writing is great, don't get me wrong. If that's the one you've got nearby, do that. It will tighten up your writing processes. But persuasive writing goes a long way, because what's the point of the narrative part of your report? To persuade your reader that your conclusions are correct. Okay? And if you can do that, if you understand the fundamentals of how to use words concisely, again, it doesn't have to be War and Peace. We don't need 75-page 1004 forms. Talk to Scott Reuter, talk to Lyle Radke. They're not interested at Fannie and Freddie of receiving 75-page 1004 forms. Not their bag. They would prefer that you didn't. But actually give the readers of these reports something to consider in a persuasive manner. How do you make your reporting? How do you make your overall product more credible? Grab the reader by the nose and drag them to your conclusion and give them a reason to believe you. And you do that by persuasively writing. And the way that you persuasively write is you explain what you've considered, why it led you to make the choices that you made, where those choices led you, and it takes you down the path to your final destination, all along the way, building credibility and explaining to the reader why they should believe you. So inside of appraiser education, think about going back to the basics again. It's significant. Outside of that, a persuasive writing course would go a long way to eliminate so many of the questions that come up with appraisals, because the questions are asked by readers that aren't able to find the answer. If you answer the question before the reader has an opportunity to ask it, I mean, bluntly, you're drastically reducing the chances you're ever going to need to pick up the phone and call someone like me. And that goes a long way towards sleeping better at night, if you can rest easy knowing that you're not going to need to go and find me or Mel or Peter or whomever else is in this space. You don't need to know us. if you've already answered the reader's questions before the reader can think of the question.
Hey, Craig is referring to Mel Black and Peter Christensen. All right, Craig, thank you. Very profound, very clear. I appreciate that clarity. I appreciate your candidness, your candor. Again, if somebody needed to get in touch with you, how would they do that?
So again, the website for the whole firm here, fgcclaw.com. Also, if you call in to the main desk, it's a switchboard up front. We are area code 847-701-2250. Catch the person at the front desk. They can direct you right to my office. And if you are looking for email, it's just my first initial and my last name at that web address. So it's CAPILLA at fgcclaw.com.
And Craig, there's some conventions coming up. There's the Appraisal Expo and the Appraisal Summit. Are you going to be at either one of those?
So I will be at the summit in September. I am not at present scheduled to be I'm not present scheduled to be at the expo. I'm trying to limit myself. My wife and kids love if I limit myself to about one road game a month. So at the moment, my August is actually going to be out in Seattle with the Farm Credit Services folks and their Risk 360 conference. So that's my August event. September, I will be at the Appraisal Summit. So anybody who's coming out for the National Association of Appraisers and Appraiser e-learning and their Appraisal Summit in Las Vegas, that'll be my one Vegas trip to check that box for the year. And then we've got some more starting to pop up in the fall already, but that's next one. So I'm almost certain I will see you in September in Las Vegas. Am I correct?
Yes, I'll be there. Scott Cullen and I are presenting a class on using Excel to derive adjustments. That's Saturday, the 16th.
Okay, very good.
And then both of us will be there for the remainder of the conference. So, Craig, again, thank you. My best to your family. I appreciate your time. I appreciate your expertise. I appreciate the fact that you help appraisers out when they need it. Thank you very much.
Thanks, Tim. Appreciate being here.
We'll be in touch. You be safe. My best to your family.
You as well. Thank you.
Thanks. Bye-bye.